And so it's legal time, and our legal eagle, Anthony Wooding from Kerseys Solicitors, is with us today. So good morning, Anthony.
Good morning.
Good to see you once again. Today we're talking about an interesting case about wills. Writing a will is a way of ensuring that our assets are distributed in accordance with our wishes when we die. However, a recent ruling in a very long-running case on a disputed will has raised some eyebrows in the legal sector, with wills and probate specialists speculating about the implications of this case. Perhaps I ought to just quickly outline the case, and then you can talk all about what the implications are. What this is all about is a mother who was estranged from her daughter. Her daughter went off and left the house at 17, and they kind of fell out completely. And when the mother wrote her will, she decided to leave it all to the RSPB and the RSPCA. It's about £500,000. She did indeed die and left the daughter with nothing. The daughter then challenged the will, I think in 2004, and was awarded some money, but then challenged that. And finally, a few weeks ago, the daughter was awarded £165,000 from the mother's estate, despite actually in the will being disinherited. Now, does this mean then, Anthony, that if we do decide to leave money to A, B or C in our will, that people can challenge it and turn over what we have decided to do?
Yes and no.
I thought it wouldn't be simple.
Yeah. There are certain categories of people in certain circumstances who can challenge provisions in a will. And the most obvious one is an ex-spouse.
Okay.
Or indeed current spouse, in fact.
Pause there for a moment.
Yeah,
so if they had fallen out completely, and even if they were divorced... there would be criteria applied, like as in a divorce.
Okay. As in a divorce, if you like.
Yeah.
Similar, anyway. But when it comes to other categories, there is a category of adult children. In this case, there weren't any other children, which is relevant as well, because if there'd been other children competing, they would have had to have been considered as well. And obligations, such as moral obligations, so considerations that you might otherwise have. So in that circumstance, it was relevant to that extent, to what extent her motives were, the motive of the deceased, although it was not the decisive factor. I think this was something that has been perhaps kind of quoted a lot in the media, as if, because she did something which we would possibly might regard as wrong, i.e. Give to charities that she had absolutely no connection with. She hadn't shown any interest in the welfare of animals or that kind of thing. And in fact, the note that she left, which was pretty clear, because she did leave a note, as indeed we advise people to, although in this case it didn't help her, but she said, "I can see no reason why my daughter should benefit in any way from my estate, bearing in mind the distress and worry she'd caused me over the years." By the way, her daughter, the claimant, had sort of run away from home. I mean, it's interesting because, this is 1978, the kind of like tail end of time when people were criticised for running away from home.
Yeah.
And people did need to run away from home to get married, didn't they? I think, I certainly know people of that generation, or perhaps slightly before, who would do that, go up to Gretna Green or whatever. And she actually was happily married and had 5 children. But had nothing to do with her mother, who resented this. And
so the daughter absconded with her boyfriend at the age of 17, and the mother said, "Right, I'm cutting you out of my will."
Well, there may have been a lot of things in between. There might, for all we know, there might have been attempts at reconciliation, whatever. But at the end of the day, she left the will excluding her, and they had very little to do with each other. And so this claim was brought in these very specific circumstances. The other thing that's kind of worth saying, if people get involved in the sort of moral arguments about this, is that I noted that the wealth that the mother had was from an industrial compensation claim on her husband.
I see.
It's not particularly necessarily relevant, but it just shows you, when you have wealth, how do you kind of view this kind of thing? He was the father of the claimant. I'm surprised more of it wasn't spent, but maybe they built a house, had a house with it or something. I don't know details. So, but you look at all these factors and you try and work out what is right, given, as I say, particular circumstances that the lady, the claimant, was impecunious, and there was no connection with the charities, and these factors, and she was the only child, and these factors all put together meant that she had a claim. But obviously it went its way through the court system. It went her way in the first instance.
Because the mother died in 2004.
Yeah. Well, it's because it's gone through the appeal system to the High Court on appeal, which was the first level of appeal. And I think the charities also appealed, cross-appealed. So they were saying, she shouldn't have anything.
Because, of course, a large amount of charities' income comes from bequests and wills, doesn't it?
Yeah.
And if this started a precedent, the charities must have been worried that every old lady who leaves money to the local cat's home is actually going to have their will challenged and the cat's home won't get the money.
There won't be that because, despite what people think, because essentially you've got to be, first of all, in impecunious state. You've also got to be pretty squeaky clean. I mean, if you've done something wrong yourself, as far as we can see from this one, she hadn't, other than get married at 17 or whatever, she hadn't done anything wrong. If she'd been behaving extremely badly towards her mother, that would have been a sort of factor as well. And the fact, the lack of connection with the charities as well. I mean, if you spend your whole life supporting a particular charity,
working selflessly for a charity,
and then you decide to, that you'd like to benefit after death. I mean, it wouldn't be the only factor, but it would be quite persuasive, and also. The charities are still going to get, by the looks of it, about sort of 300,000, aren't they?
Yeah, I wonder how they arrived at that final figure, which evidently the daughter is happy with. The figure of 165,000. There's some sort of mathematical formula here.
I think it's to do with buying a council house.
She wanted to buy her house. That's what it is. I remember now. Yeah. She's got a housing association property which she wishes to buy. Yeah. But she has no. She's in receipt of benefits and has no pension.
Yeah. So what you're doing is you're saying, well, I mean, I'm not trying to take a moral judgment on this, but I can see where the judge came from, because the law is not about morals as such, but saying, well, look, what is a reasonable need here? Well, it seems to me, if she had a house, then that would release income to slightly easier life. Well, of course, when you're on benefits, any capital you get is relevant to your entitlement, and I think that was the way it was looked at.
When you say actually it's not a moral decision, but it does seem like a moral decision. It seems like Solomon's become involved here, and the judge has been wise and said, look, the charity is not in great financial need. They have got some money in the coffers. Yeah. This woman desperately needs the money to buy her home, and that surely is a moral decision rather than anything else, isn't it?
Well, it's if you're getting sort of philosophical about this, I mean, obviously the origin of law is morals, if you like. But what you're supposed to be doing is following the law, and sometimes there are elements of discretion within the law, and you're trying to work out what's fair. And this is a difficulty, I think, with law, is that you can't prescribe for every situation. So for every situation like this, you might have a more wealthy claimant who's got a job, who'd been sort of spiteful towards her mother, and a different outcome. Yeah. So you're right that it smacks of slightly more morals than perhaps when we talk about tenancy law or consumer law. But perhaps when you're engaging families, it's very difficult to avoid that.
So does this ruling then, to use a tired cliche, does it open the floodgates for people to challenge wills?
No, it doesn't change a lot. What it does do, of course, is draw it to the attention of people. We've already had 3, I think, people ring up.
Oh, really?
Yeah.
So to put it in a nutshell, the legislation which allows this to happen is not new, is it? It's the Inheritance Provision for Family and Dependents Act of 1975, so it's old legislation in all those senses. But the grounds would be financial need. That would be the overriding one.
Well, and all the circumstances of the case, I'd say the obligations that the deceased should be placed on, and also when you're looking at financial need, and not just financial need of the claimant, of the other beneficiaries as well, which in this case, other than the charities.
What if I just briefly put one other situation to you, which has occurred, I know, a few times. What if it is alleged after the will is read that the deceased was under undue influence from someone?
That's a very, very, very different thing altogether. That can result in a claim for upsetting the will completely. It's difficult to prove. There was an interesting case about Russian icons, where it was to do, it must be obviously a Russian family, and it was who inherited these icons, which weren't worth a lot of money. And apparently one of the beneficiaries whispered into the ear of the deceased at the time that this other her sibling was had tried to steal her icons, this influenced the mother of the deceased person greatly against that person, and she was cut out, and that was undue influence because she made it up. I mean, there was no she was misled completely on it. So that's a different thing altogether. And there's lots of things about wills. I mean, you could probably fill your whole show, as it were, by aspects on will. I'm not saying you should to get
it is a fascinating
one. I mean, there's testamentary capacity. You know, whether you've got the
mental
ability
faculties.
the mental faculty, which is not a simple thing.
No,
but we can do that another time, maybe.
So this is not really a landslide. Not really.
No,
I
don't think so. No,
but there are grounds to appeal. If you really do feel that you've been treated unfairly in a will, then go to the solicitor and
should take advice. I say we wouldn't do a free interview on this, but probably we'd do an hour for £100 or something like that.
Yeah.
But obviously, you know, some of these estates are relatively wealthy, aren't they? Or even if they're not, it's something you might want peace of mind on, and so we could certainly do that. But it's not a simple exercise.
Okay.
You know, you can't just turn up and say, as I've had, I'm afraid, and it's not easy because people sort of want you to get an answer. Because first interviews I find can be quite challenging because people expect is going to be the answer.
Oh, yeah.
Whereas you can see this has gone through the court system.
Yeah.
I don't know how much. When I say how much money was left, of course, quite a lot of that was probably gone in costs, wasn't it?
Well, I should think that this. Yeah.
So probably
£500,000 was left originally.
So I would imagine that 100,000. Well, I've got no idea.
You wonder how much the RSPCA and the RSPB are actually going to get.
Yes. That's absolutely right. I mean, with 3 court hearings and 3 processes, I mean, yes, I would imagine there isn't perhaps quite as much as as that was all that. Really,
sure. Thank you, Anthony. It's an really interesting story because it's a human interest story, and one wonders if it will result in a rush of people to Kerseys' front door saying, you know, it should have been my money, it's gone to my sister and she's horrible.
Well, there you are. See this. She's what? Sorry.
And she's horrible.
She's horrible. Well, that one's not going to run.
Okay.
Yeah.
She don't deserve it. Yeah. Thank you, Anthony. And of course, a reminder to everyone. 2 things. Firstly, other firms of solicitors do exist, but secondly, also, we all ought to make our wills autant.
And if you are making unusual requests in the sense of, you know, cutting out someone that you might otherwise have thought would be accepted, you would at least give a reason, as was done here, but there might be a better, perhaps a more cogent reason given, such as we've just talked about. Yeah.
Thank you very much, Anthony Wooding, our legal eagle from Kerseys Solicitors, talking about the possibility of challenging unfair wills, but there's a lot more below the surface, it seems.
Yeah.
Thank you. Good to see you.
Thank you.